and welcome to this year's webinar. Thank you.
Thank you, Abby. So we'll go ahead and jump right into our first panel. This topic, again, like I mentioned, is influence of the judiciary on the quality of democracy across Africa with a special focus on Nigeria. So as we've seen, the judiciary plays an interesting and unique role in the quality of democracy across Africa and Nigeria in particular. This role has always been contentious, but recently the judiciary has faced particular pressure from those who seek to corrupt it and dismantle it as an institution free from political interference. This panel examines the role of the judiciary historically and then turns to recent developments concerning the judiciary and democracy in Africa. Before starting this conversation, let me first introduce and welcome our panelists. So the panelists for this session, the first one is Honorable Attorney General Sylvia Ifemije, who is currently the Attorney General and Commissioner for Justice in Anambra State. Before this, well, currently as well, she's a professor of law, and prior to her appointment as Attorney General, she was a law lecturer at Nnamdi Azikiwe University, Okwa, Anambra State. The second panelist will be Bolahan Adeniran, an advocate of SDG 16 and people-centered justice, as well as rule of law and international, as well as being a rule of law and international accountability expert. He previously served as the Attorney General of Ogun State in Nigeria and a senior investigator with several international bodies, including the International Criminal Court. Next, we have Brian Kagoro, the Program Support Division Director of the Africa Regional Office of the Open Society Foundations. Prior to that, he was founder and executive director of UHAI Africa Group, a governance and development consulting firm with operations in Johannesburg, Harare, and Nairobi. Brian is a Pan-Africanist and a constitutional and economic relations lawyer. Finally, we have Osaro Egbobamien, senior advocate of Nigeria from the founding partners of Perchstone and Grace. He's also the managing partner of the firm and currently leads its dispute resolution and banking finance group. He was admitted to practice in England and Wales in 1989 and was later admitted to practice in Nigeria in 1991. He is renowned for the depth of his knowledge of law and has, over the course of his career, distinguished himself in a string of notable cases. So those will be our panelists for the first session. Thank you so much for joining us again. And Honorable Attorney General Sylvia Ifemije, I would like to start with you. So I know you have some slides, so we'll put those up. And the question I wanted to ask you is, what is the judiciary's role in democracy in Africa?
Hello, good afternoon. Good afternoon, all, ladies and gentlemen. Yeah, can you ask the question again?
Yes. And I have your slides up as well, so please feel free to let me know when to change. The question I had was, what is the judiciary's role in democracy in Africa?
Well, judiciary is the third arm of the government that's supposed to protect and uphold the rights of citizens of Nigeria. They should be the voice of the voiceless. That's the role they should play, to see that, in fact, without the judiciary declaring the rights of the citizens and liabilities, if where it is necessary, find out that our democracy will remain stagnant. It will never grow. So their role is very indispensable. Thank you.
Thank you. And Mr. Adeniran, what is your take on this question?
Thank you. Let me first of all express my gratitude for the invitation. Really, it's to honor an individual that we've all come to respect. And we believe he has been at the forefront of fighting for the best possible judiciary that we can have in Nigeria and elsewhere in Africa. And he's someone that is obviously not afraid to speak his mind. Now, to your question, I think, we can say theoretically, yeah, judiciary, third arm of government, last hope of the common man, they are the ones that interpret the law and ensure that the law is to be followed, no matter who it is that is before them. But we know that, there are issues in terms of independence, there are issues in terms of funding, and there are always issues where we tend to debate, who's responsible, whether it's the executive, the judiciary, or the legislative arm of government, and those tend to be what we get bogged down discussing rather than focusing on the judiciary per se, in terms of what their role should be. I think we all recognize that there is a problem. There is a problem in terms of whether or not the judiciary is delivering on what it should be delivering, offering judicial service in the form of and something that. And so if it's a public service, and which means that it is the public that the service is being rendered to, which also means that it's people at the center of those services, and therefore it's the people that should benefit from those services. And the question, of course, is this what is happening? And is this what we can aspire towards? And so just to stop here and say, yes, judiciary really should have a significant influence on democracy in Nigeria. They had, their moments, especially in the 80s, which were very important towards, the democracy that we have. Whether they're still playing that role, there's a big question mark, and I think that's what we're here to discuss, and some subsequent questions.
Thank you so much. Going back to our other panelists, do you have anything you want to add to what was just said? Or Attorney General Sylvia, do you want to go through the slides that you shared with us earlier?
Yeah, I'm ready, in the absence of any of our input. Yes, the title of my presentation, I think before I start, I want to thank you for organizing this webinar in honor of Professor Chidi Odenkalo. We all together during our Truth, Peace, Justice Commission, which just submitted a report to the Anambra State government. He was our chairman and gave me the opportunity to work closely with him and know the type of person he is. And I'm so happy that I'm part of this this webinar organized in his honor on his birthday. I wish him more years, more fruitful years. Yes, the topic of my presentation is measures to strengthen the integrity and capacity of the judiciary in Africa, Nigeria, as a case study. Next slide, please. Number one of the measures I'll dwell on now is adequate remuneration of judicial officers and workers. There is need for independence and autonomy of the judiciary as the third arm of the government. It should be upheld. Poor and inadequate remuneration of judicial officers and workers at various hierarchy of the courts in Nigeria is the bane of systemic corruption within the judiciary, with the attendant consequences of unfair and substandard justice delivery. I'm happy we had Justice Summit about last month with the Attorney General of the Federation and judicial officers, and they were told that the federal government has approved a very good pay package for judges and judicial officers, and I'm happy that at least this will go a long way in ensuring that they live above board. Then number two is The second measure is the development of a functional and transparent process of recruitment and appointment of judicial officers in order to ensure that only lawyers who are sound and knowledgeable in law with tested and proven integrity fit to uphold the sacred scepter of justice are appointed to man our courts. Again, still talking about the transparent process of recruitment, I also want to say that the institution responsible for the recruitment and appointment of judicial officers must be constituted in such a manner as to ensure its independence from any external interference from government and non-governmental influences in carrying out its functions. Again, there should be a system of monitoring, checks and balances to safeguard against arbitrariness, partiality, ethnocentric, and or other ulterior considerations in the process of recruitment and appointment of judicial officers. To ensure this, the recruitment and appointment process must be done strictly according to pre-established legal guidelines. Sorry, I didn't tell you to move to the next slide. I think the fourth slide. Yes. The next one. Yes. Now, the third measure I'm proposing is the need for continuous periodic training and retraining of judicial officers and workers on the evolving international best practices in the judicial process. Next slide. It is sad to note that most of our courtrooms in our jurisdictions are still administered by judges and justices who are not computer literate. They still record court proceedings in longhand and are yet to be availed of the enormous and vast benefits of the computer and digital system, which ought to make their jobs easier and less strenuous. Most of them still engage in analog methods of search for legal materials and authorities, which ought to be available to them at their fingertips. Were they able to access digital services? Virtual hearing facilities, where they are available in court, are not being put to effective use to achieve the targeted efficiency and effectiveness in quicker justice delivery. This is very often due to lack of requisite knowledge and skill required to operate these facilities. A case in point, in some states, find out that the Attorney General will fight to see that the ESCO memo on establishment of virtual hearing facility is approved and money is released. Funds is released by the state government, the contractor is engaged, and he puts up the virtual hearing facilities as far as, at least, as far as criminal cases is concerned. But you find out that the facilities will just be there lying waste without being utilized by the judges. And it's just, it gets annoying and frustrating because when you try to see how you can help to make things faster so that the criminals, the inmates of the correctional service center will be able to access justice even from the correctional center, avoiding all these excuses of vehicle not being available to bring them and that. So it's very frustrating when you try to install these things that they are not being put in use. And at the end of the day, you find out that it's because they are just not computer literate. Fourthly, the fourth measure I want to propose is that the government needs to create, next slide, please. Yes, you are there. It's okay. The government needs to create a safe and secure judicial environment to guarantee the safety of judicial officers and workers as they go about carrying out their functions. You know that in recent times, the whole of Nigeria has been facing security challenges here and there. In the Southeast, we are really not finding it funny any longer, but we pray that not before long, everything will be put on check. So they need this to be secured so that they don't walk on that fear. They need to be assured that their lives will be secured while they go on discharging their duties. Next slide. Yes, in recent times in Nigeria, insecurity of various levels have occasioned untold disruption and interruption in judicial proceedings. Judicial officers have cancelled, suspended, and adjourned sitting for varying periods of time due to security threats. In Anambra, for instance, the state I come from, found that some states, some magistrates are not sitting because usually the JSC, Judicial Service Commission, meets on monthly basis to assess what the magistrate, their inputs. But most of them would have nothing to turn in because they've not been sitting as a result of security challenges. But now the security situation is improving. Is now becoming a thing of the past. So that security issue has to be looked into. Then the fifth measure I'm proposing is improved public enlightenment on the need to safeguard. Next slide, please. Yes, you are there. Improve public enlightenment on the need to safeguard and protect the judiciary as the last hope of common man. The judiciary is the last hope of common man, and the judges should make sure that they live up to that expected standard. The citizens look up to them to uphold their rights. You don't need to get compromised. Once you get compromised, then you can't think straight again. Your judgment will be crooked. Anybody there in the court listening to your judgment will know that something has happened behind, and that is not a plus for the judiciary. Next slide, please. Yes, thank you. The place of the judiciary as the guardian of the conscience of the society lends it easily susceptible to verification by the public, where it is perceived to fall short of societal expectation. The judiciary is often unfairly and harshly censored by the public, mostly due to ignorance and lack of understanding of the judicial functions and processes. No doubt that sometimes the judiciary has clearly allowed itself to be influenced by external forces, and the public outcry on such occasions were justified. However, there is need to enlighten the public through public orientation to understand that no system anywhere in the world is perfect. Hence, the need to exhibit empathy and understanding while constructively demanding better justice delivery. Next slide, please. Yes, the sixth and the last proposal measure I'm proposing is the need to strengthen other complementary actors and institutions who work together with the judiciary in the justice sector to achieve the ideal of effective and efficient justice delivery. It must be noted and emphasized that the judiciary is only one among other justice institutions in the chain of justice delivery. Among these other associate institutions and stakeholders are the Ministry of Justice, the police, correctional centers, various law enforcement agencies and organs of the government, and the litigation public, whose role more or less affects the end of justice delivery by the judiciary. All these institutions must be on top of their game for an efficient and effective justice system with capacity to deliver the ideals of justice to be attained. Thank you.
Thank you
Thank you
so
very
much. Sorry, I didn't mean to interrupt you. Go ahead. Sorry, was there anything else you wanted to add to the presentation?
Okay, no, well, as I said earlier, this is a good topic. It's a high time we looked at or measure the performance of the judicial officers. And when citizens begin to say let nothing, that they pray that nothing will make them go to court for any reason, then we begin to have a rethink. It means that confidence the people have in that system, that judicial system, has eroded. And that is not a plus for the judiciary. It is really not a plus where the litigants have the impression that is the highest bidder that gets justice. That means the poor cannot access justice. So I think this topic is quite topical, and I pray that at the end of the day, we'll be able to provide solution to these challenges we're observing in the judiciary. Thank you.
Thank you so much. And that is a really nice transition into the next question I wanted to ask our panelists. So you mentioned that confidence in the judiciary has been eroded, and people don't want to go to the courts anymore. And so I kind of want to tie that back to our conversation about democracy. So our next panelists, again, Mr. Adeniran, and then also Mr. Chinedu Onyezu will bring you into this conversation now as well. I'm wondering, what are your thoughts on where and how the judiciary has been able to advance democracy? But also, how has this ability to advance democracy been weakened, especially in recent times? So Mr. Adeniran, or I see Chinedu unmuting. So do you want to go ahead and then we'll pass it to Mr. Adeniran?
Yeah, it's okay. Thank you for having me here during this panel session. My name is Engineer Chinedu Onyezu. I'm not a lawyer, but I'm a politician and a youth development advocate or youth leadership advocate in Nigeria. I joined this panel to actually speak from the angle of a victim of a dysfunctional legal or judiciary system in Nigeria. Just to bring things to perspective, I contested as a young candidate in the last elections under the Labour Party, Democratic Party in Nigeria and in Abia South. Unfortunately, my aspirations of representing my constituency in the floor or on the floor of the Senate was cut short by the judiciary in the country. As everybody knew, the Labour Party won almost all the elections in the southeastern part of the country. We had very heavyweights that contested with me, and then I contested against the incumbent governor of the state, and also a 16-year sitting senator as at then. And then I ran as a youth candidate. By the way the people wanted change, we came out top in the elections. But unfortunately, due to corruption in the judiciary system, the mandate was taken away from me. I try to use this story so that I can bring things to perspective so we appreciate how bad the system has become. I engaged two senior advocates, SANS, to represent me in court and see whether I can get justice. We're talking about a scenario where we collated polling units level results, and when we presented them as against the announced results, we were some thousands of votes, above the second, the candidate that was announced the winner. And what my lawyers were just supposed to do was to simply defend those votes, or those results, which came or which were collated at polling unit level. But unfortunately, we ended up with a scenario where a senior advocate of Nigeria who I had hired to represent me colluded with my opponent and decided not to serve my opponents so that I can be taken out of the case or the matter on technical grounds. So that is to highlight the level of corruption in the judiciary system. And it requires a lot of reforms for us to have a democracy that the people can believe in and trust in. It's not just about the judges, but the entire value chain, the lawyers, the senior advocates that represent Nigerians in the court. We need to, sanitize the system, because an analogy that I always use when I discuss my matter in public is like, someone that is sick, and you go to your doctor because you know you can't treat yourself. You are hoping that your doctor is an expert in medical matters. You go to your doctor for help. You are looking out for him to, resuscitate you. But, you now have a scenario where an opponent, bribes your doctor or incentivizes your doctor to, to inject some foreign substance so that you pass on. That was really my experience in the last elections. So again, judiciary democracy, they both has to they all go together. The judiciary has to be reformed. We need to sanitize it for us to strengthen democracy in the country. I agree. I came into the ring as a newbie, pretty naive, but I campaigned, got our people to believe in my, in my manifesto. They came out in their numbers and voted for me. I had evidence to also show that, we won the elections at polling unit level, So, but unfortunately, I paid and relied on a senior advocate of this country who decided to parley with my opponent and got me out on technical grounds. So apart from the reorientation and the reforms that I suggest, the people need to also know, we need more awareness. The people need more awareness on what to do in such scenarios. Because at the end of the day, I was confused. I didn't know what next thing to do because I'm in a situation where a senior advocate of Nigeria that should be representing me, sold me out. So in terms of tying it to encouraging youth participation in democracy, advocating for youths to join, in the leadership leadership call in the country. They need to be oriented on what next things to do in a scenario where your own lawyers disappoint you. Are there ways the state governments or the national bodies can step in to help make sure you receive justice? Thank you.
Thank you so much. I'm wondering, our next panelist, Mr. Adeniran, do you have anything to add to what was just said, or any other thoughts on the question that was raised earlier?
Yes, thank you very much. I think I would like to focus on what I think the judiciary can do going forward. So, prescriptive suggestions as to how we can move from where we are. The first point I think to note is that only 1% of Nigerians who decide to take legal action or to take action to resolve a legal problem actually go to court. This was the finding of the Hague Institute for Innovation of Law in the 2023 Justice Needs and Satisfaction Survey. 5% go to lawyers, 24% go to friends, 11% go to the police, and then 43% go to family members. And I say this because one is to recognize that the judiciary can only do so much. That's one. But two, also to emphasize that there is, and it's important to focus also on informal dispute resolution, an alternative dispute resolution, in order to declog our courts and also to ensure that justice problems or legal problems are prevented before they essentially escalate. We are at a point now where people actually find going to court a joke. And I think this is what majority of people will agree with. It is time wasting. And even when there's a resolution at the end of the day, that resolution is not sometimes satisfactory to even the victim. And so many people consider going to court problematic. We find now that many are going to the police on civil issues. You have a landlord-tenant dispute or a land dispute, and it's the police that people rely on rather than judges. As we've seen, as has been said, there are issues of competence, there are issues of integrity, and there are also issues of reluctance to embrace technology and innovation. And as the world is moving to a more people-centered approach to administering justice, I think this is the time really to encourage our judges as well to start doing so. And so I want to focus on what judges can do and not enter into the debate as to whether it's the executive that's responsible or whoever else is responsible. What can judges do now? With the current crop of judges that we have, what should they be focused on? Now, say is to essentially encourage them to pivot to people-centered justice. And what would this entail? It would entail a series of actions. One is embracing data, and data to assess their performance so that the public that essentially is a beneficiary of their services can say whether or not they're satisfied. And it's possible to evaluate their performance just looking at the data. The data will also help them to be more efficient in the way they organize themselves internally. That's one. Two is to embrace technology and innovation in order to improve on their services and how this is rendered. Three is to start looking at best practices, both within the country, outside the country, internationally. The number of practices that many have embraced, many have started to utilize in order to improve on judicial performance, and there can be a focus on that. Four is to adopt an interdisciplinary and public-private partnership approach, which means to essentially embrace the fact that not only judges can solve justice problems, and not only lawyers also are the solutions to all justice problems. It takes a village to essentially understand the generality of problems and prefer solutions to them. And so if we start with the issue of data, for example, one of the things I found is that when people discuss problems in the judiciary, at least those problems that are not necessarily integrity-related problems, ones that the problems that have to do with capacity or competence, we tend to do so without data. And so we tend not to really fully understand the situation when we make comments. And so, for example, in, I think it was 2016 or 2017, where we were looking at data concerning adjournments and the reasons for delay in court in a particular part of Nigeria. I don't want to expose that judiciary. We found that most of the cases were delayed because judges were not sitting. Certainly, this was the case in 49% of the cases. And previously, the discourse was that, oh, the lawyers were not producing witnesses, particularly prosecutors. That was the prosecutors that were responsible for delaying those cases. But when the data showed otherwise, it was a simple solution. It was a simple solution in terms of a letter being written by the chief judge to all the judges in that particular jurisdiction to tell them that this is a problem and we need to sit up in order to address it. And then it was addressed and it became better. And so this is the value of data. How can this data be collected seamlessly? there are a variety of things now that we have that can help judges to do that. And these things are readily available if they want to utilize them. For example, there is the Corrections Information Management System, which is essentially domiciled in the Nigerian Corrections Service. It is a system that allows prison officials and court clerks to update the platform with information relevant to awaiting trial detainees. So, for example, whenever anyone is being taken, an inmate is being taken to court, the case management module that is linked to that particular corrections information management system has a form, a court attendance form, which is really just, a checklist, boxes that you just check, which accompanies the remand warrant. When he gets support, he or she, the inmate, the correctional service officials will present those forms to the court clerks, and then they check boxes like reasons for adjournment, stage of proceedings, who is the prosecution service that is responsible for this case, and that information is then entered into the system. So at a glance, you can basically say, why cases are delayed. You can look for good practices. You can look for cases that are not delayed, that are proceeding, well. And you can also tell, when a matter has been so delayed that, it can raise alarm bells. And so that data is then analyzed by an interdisciplinary team of people. So from prisons, to police, to the Ministry of Justice, to the judiciary themselves, in order to look at what is the reason for delays and the reasons for particular problems. And so this is one approach to essentially trying to review the performance of judiciary, especially when, there's reliance on data, which is, more objective. If we are to focus on the innovation aspect of things, there are a number of things. I mean, we talked about even the issue of verbatim reporting. At some point in the jurisdiction I worked as Attorney General, we developed a court scheduling and management system, which was meant to automate the back end of what judges do in essentially moving cases, assigning cases to judges, and what the judges that those cases have been assigned to, how they schedule those cases. And it was to make it more efficient and make it, essentially automate so that the judges don't really have to do much, and yet the cases will proceed, much more smoothly. It was also meant to allow judges to be able to give specific times to lawyers. So the approach nowadays is for all lawyers to go to court at 9 a.m. in the morning, and your case might be called at 3 p.m. But with that system, the idea was, well, let us be a bit more scientific about this. We understand that cases that require, 10 witnesses will take longer than cases with just one witness. We understand that cases with multiple parties also, they have different requirements. Criminal cases are different from civil. Land cases are different from, commercial transactions, and so on and so forth. So it's essentially to have this approach that if we can look at our cases and study them scientifically, we can be better prepared the way, justice is dispensed in our courts. And so the point, I think, in all of this is the judges themselves, particularly those in the leadership positions within the judiciary, they have a significant role to play to reassure people. And the first thing is by becoming more transparent. And by being more transparent, it means, can we put out data that the public can use to essentially assess our performance? And the public can use to also understand our constraints. So if they see that there aren't enough judges in a particular jurisdiction, the data is there. To essentially say, well, we need to actually appoint more judges here, because the volume of cases, even in the best system, will not be able to go through this system as efficiently as possible. And once we start having that, and we start embracing a multidisciplinary or interdisciplinary approach, and utilizing best practices from across the globe and within Nigeria, And of course, we embrace innovation and technology. I think the judiciary itself can then begin to give assurance to people that they are still here as the hope of the common man. But now, I doubt that even lawyers, and I'm not talking about litigants now, that even lawyers feel confident when they step into a courtroom that the outcome of their case will be the fair, equitable, and just outcome that their client deserves. Thank you.
Thank you so much. I'm hearing a lot that ties into this question of the judiciary and democracy. And I just want to bring back Mr. Chinedu Onyezu to kind of follow up on any of your remarks and also go back to the question of where the judiciary needs strengthening. So Mr. Chinedu, I'll pass it to you.
Sorry, can you say that again? I lost it momentarily.
Yes. I was just asking if you had any thoughts about what was just said. There was a lot that was mentioned on the transparency of the justice system and using data for people-centered justice system. So I'm wondering, what are your thoughts on that? And then I also wanted to bring back the question of where the judiciary needs strengthening and provide any concluding thoughts you have on that question.
Okay, so yeah, I think there's an opportunity to generally reform the Nigerian judiciary system. One area I think requires urgent attention is funding. I believe if they are well funded and if they are well funded, they might not be incentivized to consider the wrong, some of the wrong practices that actually hurt our democracy. And again, I like to tie this to what I advocate for, which is, youth participation in democracy and in the leadership process in this country. If they continue to rely on highest bidder gets justice, what happens is that you end up stifling the young people that are already struggling economically or financially. You are already taking them out of the whole arrangement. Then another opportunity area is to be intentional about supporting this category of people that make up the society, and again, young people that have good ideas and are very passionate about serving the country. If possible, and this is in the context of democracy, if possible, I will advocate for a special arrangement for these young people when it comes to defending their cause, defending their cases in court. One major barrier, again, is financial. Someone shouldn't be denied justice because he doesn't have money to pay lawyers, pay them enough, So I think there's opportunity to make it inclusive for people that have good ideas, good vision, and are passionate about serving the country. Thank you.
Thank you so much. I wanted to open up this conversation to our audience now for a Q&A session before we take a quick break and move on to the next panel. So please feel free to raise your hand, drop your question in the chat box or the Q&A box, and I'll try to ask our panelists 3 to 4 questions at a time, just so we can discuss as many of them as possible. So while those questions are being brought to the chat box, I see one question in the Q&A box, kind of going back to this theme of the judiciary in Nigeria and democracy. So the person is asking, what are the ways through which ordinary Nigerian citizens can kind of bring attention to judges? Or I guess for me, this question is kind of getting to what is the role of citizens in engaging with the judiciary and kind of pushing for it to do better. So I'll open this up to our panelists.
Maybe I can start and then others can join.
Sure.
I think citizens have a very important role. The first being to be fair in their criticism of the judiciary. One thing that we must always understand that there are always two sides to a dispute, and one side will always be not satisfied. And so even when we criticize the judiciary, it needs to be done in a way which does not essentially denigrate them or present them in bad light. Of course, we have to be fair. If what they've done requires something different, then I think the approach of presenting all sides of the story in the way we criticize is important. And that's the way I think Professor Odinkalu has been criticizing the judiciary. He has been exposing them when, for example, issues of conflicting judgments on similar issues at essentially almost at the same time. Cases where it's very difficult to understand how a decision was arrived at, especially when parties did not even ask for a particular relief in court. And so I think there are many issues here, which is one, for citizens to be vigilant, two, to be fair in their approach when it comes to citizens, three, to offer their services and not necessarily offer their services in a way that will compromise the integrity of the judiciary, but to offer their services in trying to propose solutions, in trying to develop ideas, in trying to solve particular problems that we typically know that the judiciary faces. Just to give you an example, the correction information management system was developed by a citizen, by an ordinary person. But that's a solution that even the judiciary can benefit from. The case management and scheduling system that I mentioned was also developed by members of the public. So we can come up with solutions to try and help judiciary to improve on their services. And then we should also, I think, I'm not getting into this at all, but we should also recognize that some of the challenges they face are also challenges occasioned by an overactive executive that tries to assert control over other arms of government. And so trying to, or helping, understanding the dynamics and understanding that sometimes judges are placed in a very difficult position for them to truly be independent would also help us to address the issue, perhaps at the heart of it, by appointing or electing those who have integrity to positions of the executive, and also challenging them when they do things that they ought not to do. But let me stop with these few thoughts and open it up to others as well. Thank you.
Thank you. Do any of the other panelists have thoughts? Because of time, this will be the last question for this panel, but we'll keep discussing the questions in the subsequent sections. So I see, Joelle, you have your hand raised, so jump in.
Thank you so much. And thank you to the panelists for your interesting observations. And I'm just wanting to pick up on a tension between two things that have been mentioned, which is one, the resistance of judicial officers to IT and the use of tech, and the solutions that are being suggested by our colleague Adinaran, which is related to embracing tech and embracing in the data and the innovation. And I think my experience, which comes from looking at other judiciaries in Africa, and so comparatively, I've seen a difficulty in aligning these difficulties between resistance to tech and embracing the future, which we have to, particularly as AI becomes more prevalent. And I think that it's interesting to note that in some of the Southern African jurisdictions, Malawi, Seychelles, and Namibia specifically, where they've embraced a lot of modern technology, it's failed because of a lack of good leadership. And where it has worked, for example, in the Gauteng jurisdiction in South Africa, it has only worked because of good leadership and a real commitment to it from the top. And so I think that's one of the things that I see from a comparative element is the importance of having strong leaders and kind of change management champions. And I wondered whether how we align that in the Nigerian judiciary situation, where you've also got a high level of resistance to technology, and whether you had any comments on that from either of the speakers. Thank you.
Thank you. Sorry, just want to jump in because I'm noticing time. If you could keep your comment to like about 1 minute, that would be great. And then maybe in one of the next sessions, we can pick back up on this theme.
Yeah, thank you. I think that's a very good point, and it is something that is also prevalent in this society. You are right when you say that leadership is a crucial aspect of it, and the leadership particularly focused on understanding change management, how to essentially, get everyone to, first of all, consult everyone in developing the solution. Make sure that everyone has an input, make sure that everyone has a say, make sure that you try as much as possible to incorporate their viewpoints. On one particular occasion, when we tried to introduce a new technology in a particular context, not the judiciary this time, we started talking to those who were least technologically savvy, so as to get their perspective and understand that if they can do it, well, everyone else can. And I think also with judges, that's an approach that one can also take. And essentially, when you do it, try to pilot it with a small group. Understand what the challenges are when it's with that small group, and then again get them to speak to their colleagues. I find that people are more receptive to listening to what other colleagues say, especially in the same context. So if you're speaking to judges, let Nigerian judges speak to them, especially Nigerian judges that have been successful, essentially, utilizing that approach. And then just a slow change management process where everyone is motivated from the beginning, and where it's properly coordinated, it's consultative, it's a bottom-up and top-down approach, meeting in the middle. I think it will work as long as all parties are sincere.
Thank you so much. I didn't want to cut this conversation short, but we still have a lot more to get to. So now we'll be taking a short 5-minute break. So that will be about 4:04 p.m. West Africa time. And then we'll come back to discuss the impact of the judiciary on Africa's civic space and human rights. So see you in a couple of minutes. Thank you.
While everyone is taking a health break, there's a question in the chat that asks, what impact does the application of Sharia law have on minority religious and ethnic groups within African countries? And how do judiciaries address the issue of inclusivity and discrimination? I think we'll take that in the next panel, which we'll be taking off in a minute. I'm just going to make a quick check with panelists to see that they're ready. Thank you.
Okay, I think we're gonna return from our short break now. So panelists and attendees will now be turning to our second panel. So Abby, if you're here on the call, I'll let you get started with that panel.
Sure. Welcome back, everyone. So the next section of this webinar would be focusing on the judiciary, the civic space, and human rights in Africa, and the history of the judiciary and its role in advancing democracy is well documented, but its role in advancing human rights in Africa has also been under the radar for quite a while, and also Africa's shrinking civic space. We will now examine the role of the judiciary.
Sorry, Abby, I'm not sure if we can hear you right now. Am I the only one who's having some challenges?
No, there's a bit of an audio issue. Yes.
Okay.
Might be your microphone. I'm not sure.
Now?
Yeah, now we can hear you.
Okay, great. So I was saying that we had expected to have Don join us, Don, the Chief Executive Officer of the Pan-African Lawyers Union. Unfortunately, his flight was moved and he is unavoidably absent. In his place, we have Miss Esther Maiga Maro, who is a lawyer and also the program manager officer of the CEO of the Pan-African Lawyers Union, PALU. We also have Jessica Njidike Ofia, who's a lawyer with more than 15 years experience in human rights and access to justice, and whose experience spans across women and children's rights, conflict resolution, sexuality and reproductive health rights, and is an activist in the Nigerian civic space. She has done a lot of work with a lot of UN agencies, including the UNHCR and UNICEF and UNIDO, and serves as assistant director of legal in the Lagos office of the LACON, and is also a consultant on sexual and reproductive health rights issues. Welcome, Jessica, and welcome, Esther. Esther, we'll start with you very quickly, and I might just ask Hioma Obibi to join us as well. But let me start with you very quickly, Esther. You've done a lot of work on the civic space in Africa, particularly human rights, and the work Palu has done with the judiciary across Africa. This is something that Professor Chidi Odinkalu has written so passionately about, and in more recent years seems to have gone to the depths of the brain of these issues in Nigeria with the judiciary, on democracy, on elections, on human rights, and the civic space. Esther, what's your experience being in this space, dealing with the judiciary, and are they advancing or constricting the civic space and human rights on the continent?
Thank you. I'm trying to pronounce your name, but I don't want to get it wrong.
Just call me Abby. Everyone calls me Abby.
I'll stick to Abby. Thank you, Abby, and thank you everyone who's joined this. Let me start by first wishing Professor Chidi a very happy birthday. It's such an honor to know this great man and just to have experienced and listened to him and drawn from his cup is something really that I truly treasure, and I'm grateful to my boss that I got to meet Chidi through him. So back to your question, Abby. I would say it depends with where you are. There are countries that have made steps towards the judiciaries, protecting civic space and advancing human rights. And there are states that are taking 10 steps backwards. And sometimes a state takes 5 steps and then a regime changes and we go back 10 more steps. And I'll give an example of the East African Court of Justice, which is where we litigate a lot, as well as the African Court on Human and People's Rights. In the recent past, the court has grown some teeth, I would say, and given some very good judgments that advance human rights and protect civic spaces. A very recent case is the case that was brought before the court that challenged the ruling by the Supreme Court of Kenya, in which it had locked out a politician who had run for governorship. And the reason that she had been locked out was that the time period within which cases concerning elections are to be heard had lapsed. Yet this was not a fault of her own. She had already lodged the case. It was going through the process of appeal. And by the time the Court of Appeal said now it should go back to High Court to be heard on merit, the time had lapsed. And she went to the Supreme Court, and the Supreme Court is like, our hands are tied. The time within which we can hear election petitions has elapsed. And she moved to the EACJ, and the EACJ gave a very solid decision in which it said that clearly her right to fair trial and access to justice had been denied. And this for me was such a great step that we can see a regional court that is having the guts to tell off states, because the action of the judiciary in this case was being attributed to the state. So, and this is not the only case. We've had other cases at the African Court, at the EACJ again, where the courts have clearly said, you are stifling civic space. We challenged some laws in Tanzania that were aiming at crippling freedom of expression. And the EACJ again pronounced itself. And in fact, the government did go back and do fresh laws that at least tried to be in line with ensuring that there's protection of freedom of expression. So I would say to a larger extent, depending on where you are, there's growth. To some, we seem to be going backwards. And I would say it really depends first on how progressive a constitution is, because some countries still have very retrogressive constitutions where you find the judiciary is so much in bed, for lack of a better word, with the executive that they do not want to make any decisions that will offend their masters, in this case, the executive. So there's need to keep pushing for more independence of the judiciary. I had my lady say maybe paying judges better might lower chances of there being a partiality. I don't know to what extent, because in most countries, judges are very well paid. So I don't know how much more we can pay to make sure that they're independent. So let me stop there for now.
So maybe we're paying them too much. Maybe they're so attached to what they get that they're not independent. But
Or they want
maybe they're not independent. It could that also be a risk factor? But I'm going to go to Joel really fast, considering the work you've done across the continent as well, and your perception of the judiciary, their influence on the civic space and on the development of human rights on the continent.
Brilliant. Thank you, Abby, and thank you so much, Esther, for starting off this panel. And it's interesting that we pick up straight after the discussion of financial independence, because that was something I wanted to touch on, which was something that I think is a big threat to judiciaries. And in the increasing politicization of the judiciary and the increasing judicialization of politics across Africa, the control of finances is one of the big areas where the executive has such a high ability to push back against the judiciary. And so one of the first things I was actually going to talk about was the need to promote the financial autonomy of the judiciary. So not necessarily to pay judges better, but to allow the judiciary as a whole to control its finances itself in order to have better flexibility. Of course, we've seen it's not uncommon for budgets to be cut, infrastructure projects to be canned, and pension laws to be changed in response to brave judiciaries as a direct pushback from the executive. So it's an area that I think we need to have two areas, and this comes back to the civic space, which is courts' ability to obtain financial independence is difficult because they are, as you know, has often been said, the weakest branch, in the sense that they don't have political power. And so you have international pressure can go a long way towards promoting financial independence of judiciaries across the continent and reducing the ability of the executive to push back in the finance space. And the second one is to have really brave litigation. And so one of the instances of brave litigation was in Zambia. Zambia's constitutional court actually found that its parliament had failed to pass legislation to ensure the full financial independence of the judiciary, that they breached the constitution because that affected judicial independence. And so the Ministry of Finance must now report to Parliament every 6 months on the steps that it's taken to promote the financial independence of the judiciary. So this was brought by one of the leading advocates in Zambia, but also supported by civil society. And I think that takes me to my point about the importance of civil society and the fact that judiciaries are only able to be responsive. Courts are responsive inherently. They can only determine matters that are brought to them and matters that are brought to them well. And when we consider who brings cases, it's litigants, advocates, and civil society. And individual litigants, particularly, we're finding a lot of research now showing that courts across the continent, access to courts has become so difficult because of the price of advocates and because of difficulties in reaching a courthouse. Litigants in Malawi, for example, I think it was in a recent State of the Judiciary, report, they said about 60% of litigants were traveling more than an hour and a half to get to a courthouse. And so for each delay, it affected their ability to bring their cases. And so a lot of litigants would then not come to court at all. And the civil society becomes so important because they have the ability to access additional resources. We all know that everyone in the civil society space doesn't have unlimited resources. We know that struggle. But they do also have expertise, and that's what individuals struggle with, is accessing who's going to be a good lawyer, how do the courts work. When you are only coming to court once, you don't have that sort of knowledge. And so a shrinking civil space is really important, is really problematic. We need to encourage the civil society to be able to assist with bringing good litigation, because you can't blame the courts for not doing their jobs if the cases aren't coming to court. And that is something that we really saw in the COVID pandemic, in the response to the COVID pandemic. Some countries had a lot of human rights cases that were brought in the face of the government restrictions, but some countries had none. And that's really interesting to see, because the legal origins in those countries are quite similar. So what that has to do with what it's reflecting is either that civil society is not able to bring cases on behalf of individual litigants, or that there's a distrust of the courts. My final point here, which maybe goes to our human rights issue, actually has to do with substantive law from the practitioner's point of view and from the court's point. And I believe we need to look and relook at judicial review, the mechanism of judicial review. So by this, I mean not only common law administrative judicial review, but also judicial review in the face of challenges to the constitutionality of legislation, as well as judicial review of the actions and acts of the executive when they're taking steps which undermine constitutionalism. So a really broad range of judicial review that is from the same approach, where courts are coming and saying we need robust administrative law and constitutional norms that support the rule of law and prevent obsequious deference to ensure that the executive is held accountable, because human rights abuses are made possible by unchecked executive power. And so we need to be, and I think the key thing here is consistency, so that there's consistent rule of law norms applied not only in less political administrative matters, which is where courts are very happy to intervene when, licenses are being denied, but much less happy to intervene when there's immigration issues, or when there's state secrets, or when there's corruption cases or election petitions. We need to be applying the same standards of legality and accountability to governmental conduct, regardless of how the review comes in. And in this case, I think we need to relook at whether our forms of judicial review that we use are fit for purpose for our own democracies, for our own constitutionalism. And just look at the consistency of their application. I think that's one of the areas where in the last 10 years, some of the court's democratic backsliding has happened in this space of consistent application of the administrative law or the constitutional law standards that are there. And I think one of the elements here is a reluctance to talk back against the high executive, particularly the president. And this sort of presidential or executive exceptionalism is both outdated. If people are relying on precedent, they're relying on precedent from England in the kind of turn of the century. But it's also dangerous to our constitutional democracies. And administrations must obviously be empowered to govern efficiently, but they must also be required to adhere to the rule of law standards, which correlates to increased accountability and transparency. And I think if we can get that level of consistency right across the board, then we're doing well to support, like the judiciaries are doing well to improve rule of law across the continent. So with those thoughts, I just want to commend the various people, particularly in this room, who do continue to fight against the threats to strong judiciaries and encourage them to keep up the good work.
Thank you very much, Joel. You know, I was just thinking in 2021, we had sent we'd send a brief to the African Commission on the Twitter ban in Nigeria. It's 2024. Apart from an acknowledgement that it's been received, the African Commission has done absolutely nothing. So it's not just about us taking these cases to court, not just at the local level, but also at the regional level, and the type of responses that we've gotten. Precious told you, thank you for your patience. I was wondering what your experience has been, particularly working in Nigeria in the human rights space, working with the judiciary as well, your perception of how they've impacted the civic space and human rights in the Nigerian context. You're muted. You're mute. You are muted. Can you hear me?
Am I audible now?
Yes, you are. Thank you.
Okay. Thank you so much for the opportunity. I've really learned a lot while I've been listening to other panelists. For me, it's been a wonderful ride, so to say. The judiciary, especially here in Nigeria and in Lagos State where I practice, they have their challenges, as well as they also definitely have the potentials. I want to look at it from this perspective. For me, I know there's a call for reform, there's a call for funding of the judiciary, there's a call for a lot of things, introduction to technology, or they should update their tech skills and all of that. But for me, I want to look at it from the internal point of view. What I mean by that is the judiciary itself. For me, I think for the citizens to feel the impact of the judiciary, it has to start from the judiciary themselves. What I'm saying in essence is the reform and the change that we all seek from the judiciary has to start from itself. And I'm going to give a very practical example. I'll start by saying that the judiciary should first embrace, explore, and enforce their powers. And there's a lot of power that the judiciary have that, for me and from my experience, I think they are not using adequately enough. So I'm going to give a very practical example. I have an ongoing matter. I deal mostly in commercial matters and debt recovery. And we were doing garnishee, and in one of the prayers, we prayed that we asked for a sum that the judgment debtor should pay to the judgment creditor for not paying the judgment sum on time. And what we ask for is provided by the rules of the court. So when you're doing a garnishee proceedings and when you have gotten a judgment and you have written to the judgment debtor that, oh, we've gotten judgment against you, pay your money within XYZ dates, and the judgment debtor doesn't pay, and you have to now go for execution, for example, garnishee, going for a garnishee proceedings, the court rules provides that because you have gone extra mile and you're going to have a cost attached to the garnishee proceedings, that you can ask the court to award the costs against the judgment debtor. And we did. And the court said that the court was not going to grant it. And I was saying, this is in the rules of the court, because the judgment creditor is even suffering from it. And the court said categorically, cancel, I am not going to grant this order. So what I'm saying in essence is all the reform that we are talking about starts with the judiciary themselves.
for the citizens to feel that impact, they need to explore, they need to enforce, they need to embrace their powers. All these reforms that we're talking about, they are laws that empowers them to actually, go for these things. So it starts from them. I've had situations where you bring a clear prayer to the courts, it's there, you're citing all the authorities, and the court is telling you, cancel, my hands are tied. And I'm just wondering, what is tying their hand? Because I'm not just asking prayers in fantasy, I am backing it up with the rules of the court, with the laws that empowers you to grant me that prayer. And you were not. So most of the time, you see citizens, they just feel I can't do.
Oh no, it seems.
But it is one of the training before I became an attorney mediator with Lagos State Multi-Law Court. Because when I saw that, I mean, you're doing debt recovery, you're doing commercial transaction, and you're in court for 5 years, 6 years, and the value of the millions you're going for 5 years ago is not the same value today. We decide to, resort. So another way that the judiciary can actually, the citizens, the impact, they should embrace ADL wholeheartedly. I have had situations where there was a mediation and parties have agreed, and the party is bringing technicalities so that consent judgment, that terms of settlement does not become consent judgment. And they see court indulging the other counsel for something that is clear. Terms of settlement, it's very clear. So that is why I keep saying that the judiciary themselves needs to embrace, they need to explore, they need to
And now we've completely lost Precious. Well, while we wait for Precious to get back on, I'm just going to read some questions, and then this is for the panelists as we begin to round up to think about before we go to the next session, which I will hand over to Rachel, is in what ways does nepotism in Nigerian judiciary affect democracy, democratic processes? Okay, Precious is back. So sorry. The internet threw you out.
I don't know.
It was the judiciary. Trust me, it wasn't me.
Okay, so that's basic. That's basically for me. To round up, I'm just saying that in one word. I'm just saying that for the citizens to feel the impact of the judiciary, they have to actually explore the power they have within them. They also have to embrace a lot of ADL, and they should pay less attention to technicalities, because at the end of the day, what every citizen is after is not technicalities, it is justice. Let me just get justice for whatever thing I'm coming for. Thank you.
Thank you so much. So I'm going on to the next session. Just before we do go on to the next session, I'm going to bring in Ms. Hilma Obibi to speak about our experience working on gender issues and engage in the courts, both locally in Nigeria and across the continent, and also how victims of SGBV are faring in the African courts. Ms. Obibi?
Good afternoon. I think I've turned my camera on. Good afternoon, everyone. I think it's important, first of all, happy birthday to Chidi. Yes, happy birthday. It used to be an ordinary 12th June, but now it's a day that you share with the rest of your Nigerian patriots. I think it's important that we also acknowledge within this discussion about the judiciary of how it has failed victims of sexual and gender-based violence. A few years ago in Abuja, we had to use the regional courts, the African Commission on Human and People's Rights, under the Maputo Protocol, to take to court an issue around sexual and gender-based violence. A number of women were being picked up in Abuja, labeled as prostitutes, and being harassed. Some were being detained. One or two were victims of sexual assault by police officers. We did win that case. The case was called Dorothy Injamanze and 4 others. The judgment came out on the 17th of October, 2017, if my memory serves me right. Now, how have the judiciary failed? Because it's a long process. If you've been a victim of a sexual assault, it's easier for you to go to the police and for your family to begin to negotiate with the family of the perpetrator than to go to the court. And unfortunately, whether we like it, we don't like it, that's the situation we find ourselves in Nigeria, regardless of the Violence Against Persons Prohibition Act, regardless of the Child Rights Act. I think there are only 1 or 2 states where the judiciary is making attempts at ensuring that victims of sexual and gender-based violence get some form of justice, and that is Lagos State. And alternative dispute resolution is off the table for when it comes to gender-based violence. So they don't even consider it. But for the other states in Nigeria, there's been a complete failure to even acknowledge that within the current constitution and the criminal code, there are avenues for ensuring that perpetrators are sent to jail. Now, as others have said, we have lawyers that lack basic ethics. And so the system allows for those lawyers working with the police to begin to negotiate with the perpetrators. And so you have very young victims who have not been provided with any professional counseling, families seeking justice, especially when there's been serious damages to the physical well-being of a minor victim, and will need reconstructive vaginal surgery, etc., etc. There's been no remit because the law, it's not working. The lawyers are failing. They work with the police to make sure that somebody somewhere is collecting money, is paying for something. And so we have a situation at hand that is failing completely. And we have to find a way to make it work. And I don't know what lawyers are taught. I mean, because nobody wants to report a lawyer that's not doing their job. Nobody goes to the Nigerian Bar Association, to the disciplinary committee to report a lawyer. What tends to happen is you will hear families say, oh, I leave it in the hands of God. So leaving it in the hands of God does not solve the problem. As for victims in getting access to justice in countries facing conflict, well, we see what is happening in DRC. We see what has happened to women and girls in Sudan. We see what has happened to women and girls in the war between Eritrea and Ethiopia. So these are consistent patterns of where the judiciary is non-existent, where the judiciary has failed, and where corruption is the number one barometer of whether you get justice or not. I mean, a classic example is the judiciary in Nigeria. I mean, it's compromised. And so you don't even know where to begin sanitizing it, because the very judge that you're looking to give you justice is probably beating his wife at home, has 3 other mistresses out there, and is collecting money from the politicians. So, I mean, it's a chicken and egg situation. I'm not sure. There's some people working towards sanitizing the judiciary, Whether they eventually get to do that, I don't know. I just feel that it's compromised. The young man that spoke earlier as a youth politician, I mean, that's just shocking. How does your legal counsel work for the other side? And did he ever report this guy to the disciplinary committee of the Nigerian Bar Association? What is their role and what are they doing? So, I mean, it's a societal issue because it has an impact on everything that we're doing. If the poor individuals cannot access justice, then you will have a situation in which people will begin to resort to self-help. And whether we like it or not, isn't that what is happening at the moment? So I leave my comments there. I don't know whether anybody else working in the space of sexual and gender-based violence would want to add anything more. The reality is, it's not just democracy that suffers. Everything suffers when the judiciary is failing. Thank you.
Thank you. Very brilliantly put. I'm going to hand over back to Rachel.
Thank you so much, Abby.
Yeah, okay. There you are.
Yeah, thank you. So we've heard a lot of interesting comments today, whether about democracy, human rights, and most recently, sexual and gender-based violence. And kind of with all of these different issues in mind, and we kind of started thinking about it in the last session, but I want us to kind of turn now to the future of the judiciary in Africa. And so this question I'll open up to every single one of our panelists or anyone who wants to give some comments. So what do you think is the future of the judiciary in Africa? Where do you see things going in the next 5 years, 10 years, so on? And I'll start with Esther because I noticed she had her hand raised in the previous session.
Thank you, Rachel. I wanted to circle back to something that Abby said. She talked about the communication that they had filed at the African Commission and how long it had taken. And when I thought about it and what the future holds, it's the fact that we need to push for more competent leaders at these human rights mechanisms. And the reason I'm saying this is that a lot of the people that are nominated, the process is very opaque. You would not know how your country decided to appoint, for instance, a judge at the African court who has never probably even practiced law in the country or has never practiced as a judge, has not been a judge. And then this is the person that you take to a regional court to decide on matters that are so diverse and that touches on the continent. And just to agree with something that Ban said, she said that there's a big role that the civil society plays. And I realize the importance of this because during the last year's commission session, which happened to be in Arusha, a few organizations came up with what is called the Arusha Initiative. And the Arusha Initiative basically aims at raising awareness about the process for nominating and selecting leaders for human rights mechanism within the African Union. This was on the background of the fact that we have so many judges who come in, and if you look at the judgment and the rulings that they give, and even the length of time that it takes to deliberate on a matter, you then question on where is their commitment. I'll give an example. We have a case that was decided by the African court in their last session that has been with them for the last 8 years. The case was challenging Tanzania's judiciary and how they had handled a case, and it had taken 7.5 years to complete the trial. And this was termed as undue delay. And the African court held that it was in violation of the applicant's rights to fair trial. But how ridiculous was that when the African court itself had taken 8 years to decide on that case? So you can see how there's a clash. And so I'm hoping that there'll be more organizations, more civil rights activists that push for competent leaders and push for a process that is asking the state questions. How are you putting these judges? How are you putting these commissioners in these positions? One last comment. I note that Kenya has tried to do this. Kenya nominated a judge to the EACJ this month. I think it's this month or last month. And the LSK, which is Law Society of Kenya, moved to court and said, look, this person is not qualified to be a judge within the Republic of Kenya. So why do you think he's qualified to be a judge at the East African Court of Justice? And indeed, the High Court of Kenya told the state that this person is not qualified, and they suspended that nomination. And luckily, the government has actually withdrawn that candidate. So we need more actions like those, not just at regional level, but even at national level. And the future could be bright. We just need to push back and to know where our rights are and the fact that we do have a voice to call for change.
Thank you so much. Joelle, I was wondering if you have any thoughts on what was just said or any thoughts on the future of the judiciary.
Thanks, Rachel. I've heard a lot of comments today that have been quite overwhelmingly negative about the judiciary, as well as some that are like hesitantly positive. And as someone who engages with judicial training, I'm like a surgeon. I see everything as something that needs to be trained out. So I think that I'm pretty hopeful about the future for judiciaries in Africa. And that's because in the years that I've been working with judges, I've met, on the whole, most of them have been really well intentioned. And I think the few bad apples give a bad name across the judiciary. And in that sense, I believe education is really important. It's important for standards such as the Bangalore Principles to be well discussed and explained to judges so that they understand what their ethical duties are, and that we have perhaps better equipped vocational training for judges. And in this sense, we've got the network, a Pan-African network of judicial training institutes, so the different institutes across Africa working together in the African Network for Judicial Institutes. And I think that has a lot of potential to encourage local solutions, in the sense that, like, best practice across Africa, because I think our problems look a little bit different from the rest of the world, and they can be addressed through better cooperation and through better training and standards across the region. Also, I think common law jurisdictions have a lot to learn from civil background jurisdictions, and so this sort of training should really be welcomed. And I think that that's really positive for the judiciaries across Africa. But at the same time, we do need to address that our judiciaries are fit for purpose. And however that looks, whether that's in the appointment process, in the removal process, in holding people accountable, in supporting prosecutors who would then prosecute judicial officers who are the bad eggs, but also making sure that our processes are fit for purpose. And that is something that really requires a lot of self-reflection on the part of the judicial officers and the judiciaries as a whole, the court systems, to ensure that they're able to bring justice that's timeous and appropriate for their context. So those would be my thoughts on that. Thank you.
Thank you. I see Miss Jessica, one of our panelists. She has her hand raised, so I think we'll go to her next. Jessica, can you unmute yourself? Or Jessica, are you there? We might have lost her. Okay, I just want to be mindful of time, so we'll keep thinking about this question of the future of the judiciary, but I also want to take up a couple of questions. And so maybe when you're answering the question, also be thinking to this looking ahead theme. So I'll just read out a couple of them, and maybe a panelist who we haven't heard from in a little bit can start. So I'm seeing a question about nepotism. In what ways does nepotism in the Nigerian judiciary affect democratic processes? And what do we do about that? There's a question about how do you advise the judiciary to handle and decide matters where key issues at play are competing human rights concerns? For instance, the right to freedom of expression versus the right to freedom of religion. There's a question about the long-term impacts of judicial corruption. So what effect does judicial corruption have in the long term on economic development and foreign investment in Africa? And then one last question that we'll look at for now is the question of funds and judicial corruption. So the question says, on injecting more funds as to cure judicial corruption, how much money is enough? So there's a lot of different questions in there. Maybe Precious, can we start with you? Are you there?
She wanted you to go, you're mute. Precious, you're okay. Thank you.
There we go. Thank you.
Hear me now?
Yes, we can hear you.
Yes, can you come again? I lost a little bit of touch. My apologies.
Yeah, so I was just mentioning some of the questions from the chat and also thinking ahead to this question of the future of the judiciary in Africa. Some of the questions were also raising concerns over competing human rights interests, nepotism, and the impact of corruption on economic development. So any of that, feel free to take up.
Okay. I was actually trying to check the chat section for the question, but my network was bad, so I had to join again. So, but what I could hear is tackling corruption in the judiciary, if I got that correctly. If that's what I heard from you, so that I won't have to do what was not asked. Okay, so for me, like I said earlier, one of the panelists did talk about increase in the judge's salary, and somebody else, I think Miss Esther, was talking about there are some jurisdictions where the judges are paid very well. So what happens to them? And I remember Ms. Abiodun was like, "Oh, we're even paying them too much. Are we paying them too much?" So for me, I think to minimize corruption, it starts from the judiciary itself. So let me take, for example, you petition a judge, for example, here. Let me just assume here in Lagos State, I want to petition a judge, maybe for something. Maybe I noticed one corruption or something that just didn't go down well with me. It's going to be a long ride, a very, very long ride. So for starters, there needs to be transparency in the system. That's one. Secondly, when I feel people that come up with complaint against the judge, they shouldn't be victimized. I can tell you firsthand that if you petition a judge, you're going to be victimized for a whole lot of things. So the system should be transparent. And for me, to increase the salaries of the judges is good, to increase the welfare of the judges is good, to increase security or tighten the security, all those things are good. But truth be told, if somebody is corrupt, character-wise, everything-wise, even if you pay the person $100 million, it's never going to be enough. So I feel the system of the process of actually making someone a judge should really, really be important, should really, really be transparent, because these days judges are, I don't want to use the word handpicked for political reasons. The system should be, the process of appointing a judge should be transparent. We should go for integrity more than for political classes or for political reasons. Judges should be picked from their years, their track record, their experience, integrity. You can't choose a judge that has once been reported as a lawyer for mismanaging a client's fund. We see that. So a client has once reported to the disciplinary committee that this particular lawyer had mismanaged their fund, and then you are appointing the person as a judge. I mean, it's a whole lot. So that's basically for me. The reform should really start from the judiciary. Everything about them transparent to at least an extent. Thank you.
Thank you so much. I'll open this up to our other panelists as well. Any thoughts on what was just said or any additional thoughts on the future of the judiciary? And then we'll pass it to Dilem for the vote of thanks. But any final thoughts on these questions? No? Okay. Well, oh, yes, Ihioma, I see your hand is raised. Please go ahead.
I think finally, I think it's important at some point that when we speak about and are speaking to increasing the resources for the judiciary, the training has to be inclusive, because we find that not only do they not know about sexual and gender-based violence, they're not aware of the Maputo Protocol itself and the impact that has on the lives of women across the continent. So the judiciary itself, we're churning out these lawyers who are going to law school, but really and truly, quite a few of them, many of them don't know or understand or have seen or have read the Maputo Protocol on Women. So it's like a holistic approach. But I think the more important thing is the independence of the judiciary. We need them to be independent because they are our last resource for justice. Thank you.
Thank you so much. So that kind of concludes the panel conversations for today's session, but there were a lot of questions we didn't have time to turn to. So panelists and attendees, please feel free to keep the conversation going in the chat box or use one of our hashtags on Twitter. Now I'd like to pass it to Dilem Odinkalu, Professor Chidi's son, to give us our vote of thanks.
Hello, everyone. As Rachel has so very kindly said, I'm Professor Chidi's first son, his only son, as far as he'll let you know. But yeah, my experience with the judiciary is relatively limited. I'm not going to sit here and pretend like I'm in the same generation as all of the esteemed panelists. I'm a little bit younger, and from my perspective, the things have changed over the course of my life rather rapidly. I have, from the time when I was a younger boy, seen that there has been a progressive and almost collective effort to be better. As was said at the beginning of this, the judiciary is the third arm of government, supposed to protect. It is supposed to be the voice for the voiceless, and it is that simple. At the end of the day, if a person has no means of redress, no means of getting back, no means of rectifying what has been done to them, they need to be able to rely on a body of government to do it on their behalf. Justice should not come to the highest bidder. Justice should be unanimous. All right? That being said, we're Africans, we're Nigerians. We live in a world that is unique. Everyone has their, back home, we all have this phrase, Lagos no go spoiled, but has it not spoiled? The point of what I'm trying to make is that change can only happen if there are people there to affect it. We have sat here on this panel, numerous individuals who are in positions of power with the ability to stop. We have, over the course of the discussion, discussed the numerous failings of the judiciary. But one thing that cannot be said is that it has failed. Because the only way for a thing to fail is if people stop trying. There are loads of people here who are still trying. Everyone here is giving it their all. Things will get better. On behalf of my father, I want to thank all of you panelists for coming to celebrate his life, to celebrate Nigerian Democracy Day, to just have the discussion and be willing to actually have a chat about the things that are going wrong with us. It's not easy. We all do our parts to try and make things better. But one thing I can say is that things will get better. Or even now, they do seem to be. I want to extend a special vote of thanks to Rachel. You've done an amazing job of moderating this lovely webinar. And Mom, Dad, love you guys loads. Everyone, please try and go forward with equity in your hearts. Just try and come to equity with clean hands. As long as you have your integrity intact, God will look after you. All right? Have an amazing day, everybody.
Thank you so much for those words. Now I would like to pass it to Chepkur Sambu to give us some additional closing remarks. So Chepkur, I'll let you take it away.
Thank you so much. Hi, my name is Chepkur. This was a very insightful discussion. It reminded me that I am a lawyer, which is something I have abandoned for a long time. But happy birthday to Professor Chidi, first of all. I like thinking as a Pan-African that positively Africa is a country. And of course, Africa is not a country in so many other ways. And I think this discussion has brought that out in two ways. On the one side, we see similar challenges. And on the other side, we see different solutions for these challenges. For example, there's a proposal that judges get more salaries in Nigeria, and in other parts of Africa, they seem to be, highly paid. So these, I think it just shows us that we do need to have these conversations more and more, these conversations at a regional level to understand how we can address the fate of the judiciary in Africa. But I just want to say that in summary, the discussion has covered access to justice challenges, including technology, the time it takes to conclude a case, the distance to courts, and the cost of litigating. We have also covered corruption, trust issues that the public has with the judiciary across Africa, funding, and the independence of the judiciary, which is at stake. The trends that I think we have seen from this conversation is that because of these challenges, we are seeing more people embracing alternative dispute resolution mechanisms. Whether those are appropriate or not is a question. ADR has always been a good alternative, has always actually been encouraged over going to courts. But in cases such as sexual and gender-based violence, then we might see a problem with a lot of resort to ADR and people resorting to their own forms of justice. I think that in transition to that, the most abandoned areas here are sexual and gender-based violence cases, cases to do with transitional justice, and cases to do with conflicts, really. And I can attest to that as someone who focuses on conflicts, that victims of conflicts, when we're thinking about solutions for victims of conflicts, we barely think about the judiciary at this point. What we have not discussed, unfortunately, is Sharia law, which was raised in the chat, and how Sharia law and secular law coexist. And I think this is something we need to think about as we talk about the future of the judiciary. Emerging issues, I would say, would be what is the role of regional courts as they work with domestic courts, what avenues do they provide, consistency, filling gaps. And I think that we need to also talk about consistency of domestic courts across the board. And finally, when we're talking about the future of the judiciary, questions to put in mind are appointments of judicial officers and competence. We also need to keep in mind accountability of not just the judges, but also the lawyers, as we have had the case from our engineer where his lawyer was working for the other side. And then also constitutions and progress. Whenever there's regime changes, we see progress as not progressing sometimes with the gains that we have already made. So, which then tells us that it is important for us to advocate for the independence of the judiciary to withstand these changes in politics. And then there is three last issues I want to raise: the inclusivity. The need to have judges be more interdisciplinary and receive training on different areas, such as transitional justice, sexual and gender-based violence. Most of our domestic judges don't even understand international law fully. So that is important. I would still insist that we think about the role of alternative dispute resolution right now, especially while we strive to strengthen our judicial systems. Think about how we can also build capacity for alternative dispute resolutions to fill in the gap in a way that is not inconsistent with justice. Finally, I would say that this is a vicious cycle. I mean, we're talking about reform starting from the judiciary so that the public can trust the judiciary. But also, if reforms have already begun in specific sectors of the judiciary, while you have a general feeling of the citizens stuck with an opposing mindset to the judiciary, then you see that sort of reduces progress. So I would suggest that there is also the role for citizens and the public to play in supporting the judiciary. And I have seen this come in handy in Kenya, where I am from, where the citizens have stood with the judiciary when needed to shield them from the executive. So I think as citizens, as the public, let us acknowledge those who are doing their work in the judicial system and let us support them. With those very many remarks, thank you so much.
Thank you so much. I want to pass it back to our other moderator, Abby, to help us close out today's session. So, Abby.
Hi, Rachel. You're good to close. I think that there is only one thing left to do. I know that Professor Chidi likes to attend this meetings incognito. I have no doubt he's in the room, but silently. Would you like to make a comment, or if he hasn't shown himself, then I'm not very sure he would. But I'd like to acknowledge everyone on the call. I've been a bit distracted because a lot of people were kicked off the call and they couldn't get back in, especially our host Chinedu Orji, who's hosted this. This is the 5th or 6th time is hosting this, and unfortunately, he was also kicked off the call. But I've ensured that everyone can lend their voice to, well, maybe not to speak about the judiciary, but to say happy birthday and thank you to Professor Chidi. We have a very bad habit of singing off key every year on June 12th. We might as well do that this year. So let's sing happy birthday while he closes his ears. Shall we? You can unmute yourselves. Happy birthday to you. Happy birthday to you. Happy birthday, Judy. Happy birthday
to you.
Please,
if you're
Chidi,
up,
talk to us, please give us a
talk to
birthday
us. Yes,
present. Please
would like
present
to hear
us
you.
with your voice. Talk to us, dear Prof.
Happy birthday.
We need the cake. What is the cake?
There is only one person who can do this.
I knew it. I knew once I heard he would respond.
There's only one person who can do this.
There is no happy birthday without cake.
My August sister. Good evening. No, I can I please just my name is Chidi Anselm Odinkalu. I'm using a borrowed identity, and I want to first of all say a huge thank you to everyone who's labored to put this together. Chinedu, who unfortunately has been visited by village people. Prof. Ifemeje from the Attorney General's chambers in Awka, Anambra State. Boy, former Attorney General of Ogun State, amongst other distinctions, and the other Chinedu, of course, who shared with us his experience with the judicial system, as well as all the other colleagues who joined the second panel from different parts of the continent, from East Africa, from Southern Africa, from of course the United States, from the East Coast of the United States, and many other locations around the world. Let me just say thank you. It's never easy coordinating these things. And it's even more difficult doing it in the name of other people or, for someone else. But the fact is that the judiciary is something that's close to our hearts, for good or for ill. I spend so much time doing and thinking about the judiciary across the continent. I'm loath really to say anything on the subject matter. Partly also because I think the perspectives that have been shared are both fresh and unique. Listening to a fresh generation on the subject matter, from Dilim in Mauritius to Chep Korir in Boston via Nairobi. I feel very confident that this issue is in good hands, and I'm a little jaded. Not always bring fresh energy to the subject matter, but I like Dilim's optimism that if we, I find his optimism quite inspiring. If we can do something, each and every one of us take an initiative on our parts, collectively, we can move forwards, even if slowly. And that's really what's needed. And that's why I keep saying, because people keep asking me, why is it that how do you still find energy in the midst of all of these things? And really, that's why I went back to school. That's why I went back to teaching, because young people will always give you inspiration and energy. And how can't you find inspiration if you're in the midst of people like Rachel or Dilim or Chet Korir or Precious? People who bring fresh insights to things, people who are going to see new angles, and who are going to actually let you know that there'll be a tomorrow to wake up to, and there'll be fresh challenges, and that they can actually figure out a way around these challenges, even if the figuring out is imperfect. And so we'll continue to work at making them a lot more perfect. Everyone who knows me knows I'm a child of war. I was born in the second half of the Nigerian Civil War, and I generally prefer to spend my birthday kind of in commemoration of the children who didn't survive the war. And these days, of course, also in solidarity with lots of other children in different parts of the world, whether it's in Sudan or Gaza or Ethiopia, who are going through the violence of war. And as we discuss judiciaries, we should also keep it in mind that when judicial systems fail, we end up in mass violence, we end up in vigilantism, and we end up with children like those who were born with me who may not make it. And so that is the control. Because we don't want to end up there, ultimately, would like to do better with our systems, reform them, make them better, so that ultimately we end up with societies that are viable, serviceable, functional, and able to withstand the kinds of tests that can sometimes be thrown at them. And let me end by thanking, in particular, the biggest of my big sisters, Iyom, Josephine, and Neni, for making time to be here. I don't have any sister who comes bigger than Iyom. I just want to say thank you. And to everyone who's been able to make this, may you all be richly blessed in your days. Thank you.
Thank you, Prof. We are indeed grateful for the gift of you, and that's why we gather and we do this every year. Thank you so much. And thank you to your family as well that continues to loan you to us without interest. And thank you to everyone else, your family in Boston, your family in the OSF arena. Of course, that we must acknowledge, of course, your big sister, Josephine Aneni. Ma'am, thank you so much for making it. Thank you to all the panelists. Thank you, Dilly, very inspiring speech. Thank you, Rachel. And most especially, thank you, Chinedu, for insisting on putting this together annually. It's hard work. It takes you off of work for many days. Thank you to the people who work in the background. Thank you to you all for making Nigeria, for making Africa a safer and better place every year. God bless us. Have a wonderful Democracy Day and happy birthday, Prof.
Thanks a lot, guys.
Thank you.
Thank you. Thank you. Thank you.
Thank you.